In my 40 years on the bench, I have learned that silence is the most honest sound in a courtroom. It is in the quiet moments between the bailiff's call and the opening statement that the true character of a person is stripped bare. You see, when people walk into my room, they bring their stories, their fears, and their lies. But most of all, they bring their arrogance, a belief that they can rewrite the narrative of their own actions. This specific morning, the atmosphere felt different. The air was thick, heavy with the weight of expectation. Karen walked in, and you could see it before she even reached the defense table. The practiced composure. She wasn't just walking, she was arriving. Her blazer was sharp, her hair flawless, her gait measured every inch of her projection, screamed that she was the one in control. She didn't look at the gallery. She didn't look at the plaintiff. She looked at the courtroom as if it were a stage she had walked onto 1,000 times before. Across the aisle sat Daniel. His suit was a few years old, the shoulders sitting just a bit too loose. He kept his eyes on the floor, his hands resting on his knees, gripping his own fabric as if it were the only thing keeping him tethered to the ground. He looked like a man who was terrified not of the legal process, but of the possibility that the truth wouldn't be enough. That, in my experience, is the most dangerous position a person can be in. When the matter was called, Karen didn't just sit, she settled in. She gave the bailiff a polite, tight-lipped nod. She looked toward my bench and offered a smile. It was a smile that didn't reach her eyes, a calculated, rehearsed expression of someone who believes the outcome is already written in their favor. It was the smile of someone who has mastered the art of being unbothered. "We are here today to resolve a matter of a private agreement," her attorney began, his voice smooth, professional, and entirely devoid of heat. An agreement that, frankly, never existed. I watched Karen as he spoke. She didn't flinch. She didn't adjust. She leaned back, crossing her legs, fully prepared to treat this trial as a minor administrative inconvenience. To her, this wasn't about justice. This was about procedure, about winning, about ensuring that her version of reality remained the only one that mattered. She looked at me, not with the humility one usually finds in the seat of the accused, but with the expectation of a victor. It was a look I knew well. It was the look of a person who had spent a long time burying the truth and who had become entirely convinced that the dirt would never be disturbed. But as I looked at her, then back at Daniel's shaking hands, I felt a familiar curiosity. A courtroom is a funny thing. You can bring all the confidence in the world with you, but you can only leave with what you brought to the truth. The attorney for the defense was a master of the mechanical. Every word was placed with the precision of a surgeon, though his goal was to dissect truth rather than save it. "Your Honor," he began, his voice flat and devoid of any human empathy, "we are dealing with a simple case of a misunderstanding. There is no written contract. There is no enforceable agreement. There is absolutely no proof of the debts alleged by the plaintiff." He repeated these phrases like a mantra, a rhythmic drumming meant to lull the court into the belief that the absence of paper meant the absence of reality. He wasn't just arguing a case, he was trying to define the limits of the courtroom's reach. I watched Karen during this. She was nodding along, not with the frantic desperation of someone seeking to convince, but with the calm affirmation of a student watching a teacher deliver a perfect lesson. She was drinking it in. To her, this wasn't just defense, it was validation. Then, the floor shifted. It was Daniel's turn. He didn't have a team of expensive lawyers. He stood up, and for a moment, the silence felt heavy, suffocating. He didn't have a rehearsed script. He didn't have a polished delivery. He cleared his throat, and I could hear the vulnerability in that single, ragged sound. "I know how this looks, Your Honor," he said, his voice trembling not with fear, but with the sheer weight of being unheard. "I know there's no paper. I know there's no seal. But I trusted her. We sat in her office. We drank coffee. We talked about the future. I gave her my life savings because I believed in the person sitting right there." He pointed to Karen. She didn't look at him. She stared at the ceiling, her lips curled into a faint, dismissive smirk. It was a mistake, a small, almost imperceptible flick of the ego that spoke volumes. Trust, I thought to myself, leaning back. In my courtroom, that word is a double-edged sword. Contracts are built to protect the greedy. Trust is the fragile bridge that exposes the character of a person. In business, a contract is a cage, but in life, trust is the only currency that truly matters. Daniel wasn't just asking for his money back. He was asking for the court to validate that his faith in humanity hadn't been a sign of weakness. I looked at the jurors. Some were looking at the defense attorney's polished presentation, but others were looking at Daniel. I saw the shift. A courtroom is not just a place for facts, it is a crucible. The tension in the room began to climb, the air thick with the realization that we were about to dive into the messy, unwritten history of two lives. Karen's smile hadn't faded, but the room around her was starting to sense that something was changing. The performance was about to meet the reality. And in my experience, reality is a very unforgiving opponent. Daniel's voice cracked. He wasn't a trained orator, and he certainly wasn't a liar. He spoke of face-to-face promises, of delayed explanations, and of a rapidly expanding consulting venture that had consumed every cent he had. I watched him closely. People often forget that the bench is not just for weighing facts, it is for weighing souls. Daniel's pain was raw, unfiltered, and deeply inconvenient for the defense's polished, sterile narrative. He wasn't performing. He was simply unburdening a load that had been crushing his chest for months. Karen, on the other hand, was a study in controlled defiance. She leaned toward her counsel, whispering something that triggered a suppressed chuckle. It was a mistake. Jurors and judges noticed those small, dismissive gestures. It signals a profound lack of respect for the sanctity of the process. And in my courtroom, that is a fatal error. When it was her turn to testify, she became a statue of composure. "I never promised him anything," she said, her voice steady as a metronome. "I never borrowed money. I never signed any agreement." She looked directly at me then, her gaze locked, unblinking. "And frankly, Judge," she paused, a dramatic flair that felt as practiced as a stage play, "he can't prove otherwise." The courtroom went deathly quiet. There is a specific kind of silence that falls over a trial when someone makes an absolute declaration of impossibility. It's the sound of a trap snapping shut. Whenever a witness tells me something is impossible to prove, my mind immediately begins cataloging what they are truly afraid of having revealed. The plaintiff's attorney didn't shout. He didn't object. He didn't even look up at her. He simply reached down into a worn leather briefcase resting against his chair. It wasn't the dramatic, theatrical reach of a television lawyer. It was the measured, purposeful movement of a man who knew exactly what he was holding. He pulled out a plain manila folder. It looked mundane, the kind of thing you'd toss in a recycling bin without a second thought. Karen barely glanced at it. She smiled again, a flicker of disdain that suggested she thought the effort was pathetic. If only she had known what rested inside those few sheets of paper. I ordered the bailiff to bring it to me. I took the folder and, for a few seconds, I said nothing. Silence is a judge's best tool. It makes the guilty squirm. I flipped the page, my eyes scanning the invoices, the payment records, and the demand summaries. There was no smoking gun contract. That much was clear. But as I turned the pages, a pattern emerged, a timeline. People lie, they forget, and they manipulate. But timelines are patient. They don't panic. They simply wait for the truth to catch up. The plaintiff's attorney, a man who clearly understood that patience is a weapon, didn't rush. He didn't fire questions like a machine gun. He laid them out like a trap. He turned his attention back to the emails he had retrieved from that worn manila folder. Individually, they were harmless. A message about a meeting, a note acknowledging the receipt of some financial data, a brief, polite thank you for his patience. Standing alone, they were exactly what the defense claimed. Business chatter. I watched Karen's attorney settle back into his chair, a smug look of satisfaction on his face. He leaned toward the jury, gesturing toward the screen as if to say, "Is this it? Is this the mountain of evidence we were promised?" He was playing to the room, believing the battle was already won. But I wasn't looking at the individual emails anymore. I was looking at the sequence. A courtroom is not just a place of testimony, it is a place of patterns. One message referenced a meeting. The next acknowledged financial data. The third thanked Daniel for his patience. The fourth mentioned delays that would make sense soon. Individually, they were noise. But together, they were a blueprint. They formed a sequence that was increasingly difficult to dismiss as mere coincidence. I shifted my gaze to Karen. She was still sitting with that practiced, poised posture, but something had changed. Only a judge who has spent years watching the subtlest shifts in body language would have caught it. Her fingers, which had been resting motionless on the table, had begun to move. Very softly, very rhythmically, her index finger began tapping against the mahogany. Tap, tap, tap. It was a subtle, involuntary betrayal. Stress has a unique way of leaking out of the human body. Some people blink excessively, others clear their throats. Some become unnaturally still. Karen was leaking her panic through the rhythmic drumming of her fingers. She was no longer watching me with that confident, I'm in control stare. Her eyes were darting between the evidence screen and her attorney, a flicker of genuine irritation crossing her face. The plaintiff's attorney stood up, his voice low and steady. He wasn't finished. He walked back to the table, and I saw him reach for something else, a smaller stack of documents tucked away. Karen's attorney stood up, his objection ready, but I was already leaning forward, my pen in hand. The atmosphere in the room had shifted from skepticism to anticipation. The game was no longer being played on the surface. We were beginning to dig. The plaintiff's attorney wasn't finished. He walked back to the manila folder and removed another stack smaller, tighter. He asked permission to publish the next exhibit. Karen's attorney was on his feet in an instant, his face flushing a deep, agitated red. Hearsay, Your Honor. There is no foundation for this. He was throwing legal jargon at the wall, hoping something would stick, hoping to delay the inevitable. I held up a hand, silencing him with a single, sharp look. Overruled, I said. This court is interested in the truth, not in the technicalities of someone trying to hide it. The exhibit was admitted. I watched the bailiff place the document on the evidence screen. From the gallery, a ripple of whispers traveled through the room like a sudden breeze through dry leaves. At first, it looked like nothing, just routine office paperwork, expense summaries, shipping confirmations, payment records. Even I, with all my years on the bench, found myself leaning in, wondering why counsel considered this mundane pile so explosive. Then, I saw it. In the bottom corner of a page, a handwritten notation. 5 words. 5 ordinary scrawled words that had the power of a sledgehammer. Received from D.C. Hold until settlement. The moment I read those words, I looked back at Karen. The effect was instantaneous. She had gone completely, deathly still. The rhythmic tapping of her fingers against the table had ceased abruptly, as if a switch had been flipped. She didn't look at me. She didn't look at the jury. Her eyes were glued to the screen, staring at her own handwriting. Years on the bench have taught me that silence can confess long before the lips ever move, and in that moment, the silence in my courtroom was deafening. It wasn't the silence of confusion. It was the silence of a person realizing that their carefully constructed narrative had just been dismantled by a piece of paper they thought was long buried. Her attorney leaned in, whispering rapidly, urgently, trying to salvage the wreckage. Karen gave a slight mechanical nod, but her confidence had fractured. It was a hairline crack, but in this room, a crack is all it takes for the foundation to give way. She had built a fortress of, I never promised him anything, and with 5 words, the walls were beginning to buckle. I looked at the note again. If she had never entered into an agreement with Daniel Carter, as she had sworn under oath, why on earth would an internal business document reference his initials and specifically mention a settlement? The question hung in the air, suspended in the collective realization of everyone in the room. This was no longer a dispute about business ethics. It was a revelation of deceit. The plaintiff's attorney wasn't finished. He knew that the handwritten note was a spark, but he needed to pour fuel on the fire. He turned toward the gallery and signaled, Your Honor, the plaintiff calls Emily Dawson. A woman in her early 40s walked into the courtroom. She didn't have the polished, expensive appearance of the defense team. She wore a simple blouse and carried a binder that looked as though it had been opened and closed thousands of times. She walked with a steady, deliberate pace to the witness stand, raised her right hand, and took the oath without hesitation. But it was Karen's reaction that truly told the story. For the first time all afternoon, the smirk was gone. Karen didn't just look at the witness. She tracked her. Her eyes narrowed, her body angled away from the defense table. It was the look of a predator who suddenly realizes they are no longer the one doing the hunting. Miss Dawson, the plaintiff's attorney began, his voice calm and methodical. For the record, what were your responsibilities at Miss Williams' consulting firm? I was the operations manager, she replied, her voice clear and devoid of any nervousness. I maintained the financial files, the client records, and the internal correspondence. I oversaw the archiving of all paperwork. Routine office duties, then? Routine, yes, but meticulous. The attorney nodded. He reached back into the manila folder and pulled out the document with the handwritten note, the one that had just sent a shockwave through the room. Do you recognize Plaintiff's Exhibit 12? Emily barely looked at it. She didn't need to. Yes, I filed it. Karen shifted in her chair, a sharp, sudden movement that made her attorney glance over with a frown. And whose handwriting appears on the bottom of that page? It's Karen's, Emily said, looking directly at the defense table. She insisted on writing those types of notes herself. She didn't trust the digital logs for anything involving settlements or internal debt reconciliation. The courtroom became suffocatingly silent. It was as if the oxygen had been sucked out of the air. Karen's attorney was on his feet before the last syllable had even settled. Objection. Foundation, Your Honor. This is speculative hearsay. I'll allow the argument, I replied, my voice booming through the room. The attorneys began their dance, arguing over handwriting authentication, the business record exception to the hearsay rule, and the lack of proper foundation. It was the kind of legal wrangling that spectators find tedious, but in that moment, it was the friction creating the fire. I watched them, but I also watched the witness. Emily Dawson wasn't looking at the attorneys. She was waiting for me. I overruled the objection. The testimony was admissible. I looked over at the defense table. The smug satisfaction of 10 minutes ago had completely vanished. Karen was staring straight ahead, her eyes glassy, her hands folded so tightly that her knuckles were white. She was no longer performing. She was bracing for the truth. I have often said that the most dangerous evidence is not the evidence people expect. It is the evidence they forget exists. As I studied that handwritten notation on the exhibit, I noticed Karen's attorney leaning toward her, whispering sharply. She gave a slight, mechanical nod, but the composure she had worn like armor all day had begun to fracture. It wasn't the kind of break that makes a loud noise. It was a hairline crack in a carefully constructed porcelain vase. After decades on the bench, I had learned to recognize those cracks instantly. Before I could address the courtroom doors opened, and the bailiff walked toward the bench with a purpose that commanded silence. He carried a sealed, heavy envelope, handled with the caution one usually reserves for something fragile or explosive. The name written across the front made every attorney in the room stop mid-sentence. It was addressed directly to me, and the return label belonged to a storage company that had not been mentioned once during the entire discovery phase. Neither side knew about this. The silence in the room became absolute, a physical weight pressing down on the gallery. I broke the wax seal. The letter inside explained that Harrison Secure Records had conducted an internal inventory audit following a recent change in ownership. During that audit, they had discovered a storage box that had been mistakenly cataloged under an inactive account rather than being destroyed according to a previous, specific disposal request filed years ago. One sentence in that letter stood out like a lightning bolt. The box remains sealed because company policy requires judicial authorization before releasing materials connected to pending litigation. I looked down at the tracking number printed on the letter. It matched the number Emily Dawson had testified about only moments earlier. Coincidence? Perhaps in a novel, but judges are trained not to rely on coincidence when facts can be verified. I turned my gaze toward the witness stand. Miss Dawson, have you seen this tracking number before? She leaned forward, her posture rigid. Yes, Your Honor. I assigned it myself 3 years ago, before I was instructed to destroy the contents. Karen's head snapped down, her eyes fixed on her lap. The room temperature seemed to plummet. Her attorney quickly stood, requesting an emergency recess, his voice tight with desperation. I denied it. The jury deserved to see the reality of this moment while the truth was still hanging in the air, unpolluted by legal spin. The box existed. It was sitting in the back of the building, and it was about to reveal exactly what had been hidden in the shadows of this business dispute for years. The next morning, the courtroom was a pressure cooker. Every seat in the gallery was occupied. Reporters lined the back rows, their laptops open, waiting for the final act. When I entered, the silence was immediate, heavy, and expectant. Karen entered differently that morning. The polished, untouchable mask she had worn the day before was gone. She walked with measured, stiff steps, refusing to glance toward the evidence table where the storage box sat, the very box that held the weight of her deception. I instructed the bailiff to break the seal. Inside were the ordinary remnants of a business that had operated on secrets. I pulled out the files, one by one, and then, there it was, the yellow legal pad page, the handwritten note. Daniel keeps asking for written confirmation. Do not send emails. Handle everything on paper until funds clear. I placed it on the screen. The courtroom froze. It wasn't the silence of confusion. It was the silence of witnessing a life unravel in real time. Karen leaned toward the microphone. Her voice wasn't the steady, defiant instrument it had been yesterday. It was thin, brittle. I never thought anyone would find that file, she whispered. The confession didn't come from a dramatic lawyer's question. It escaped from the sheer, crushing weight of the truth finally being forced into the light. Her attorney closed his eyes, leaning back as if he had been physically struck. Daniel just sat there, his shoulders finally dropping, the exhaustion visible, but no longer suffocating him. He didn't cheer, he didn't gloat. He simply looked at the truth, and that seemed to be all he had ever wanted. I delivered my ruling. I found that Daniel had established his claim through the cold, hard logic of documentary evidence and the weight of Karen's own admissions. Judgment was entered in his favor, but as I finalized the order for repayment and costs, I didn't look at the files. I looked at Karen. I looked at the person who had spent months, perhaps years, believing she could build a kingdom on the sand of deception. People spend an enormous amount of energy hiding evidence, I told the room, my voice steady and final, when they should spend that same energy simply telling the truth. I left the bench with the knowledge that this was not just a financial victory for a plaintiff, it was a victory for the process. Karen thought she was powerful, thought she was shielded by her status and her ability to weave a web of lies. She learned a hard lesson that day. Character is what remains when power fails, and facts, no matter how deeply you bury them in a dusty storage box, are incredibly, painfully patient. They always wait for the day they are forced to see the light.